Hello everyone, let's begin. So we left at appellate jurisdiction. We left till here, and I have to begin from appellate jurisdiction of Supreme Court. So previous video, so far we saw that how in a federation rules are implemented by executive, parliament makes it, and the power of parliament to make rules is supreme, but it is subject to judicial review because any law cannot violate the basic structure, cannot go against the basic structure of Indian constitution. Now we will see appellate jurisdiction. Appellate means as an appeal. Okay, as we know, Supreme Court is the highest court of law in India. So if any person or any party to the suit is better to say, because it's not that always two people are involved in a matter. Two state governments or a state and central government can also be party to the suit, or two companies can be also parties to the suit. So if either of the party to the suit is not satisfied with the verdict given by a lower court, then the same circumstances matter can go up to the Supreme Court for hearing, and that is known as basically appellate jurisdiction of Supreme Court. Appeal in constitutional matters. Now here various articles of Indian constitution are mentioned, and as I always say, you have to learn the articles which are mentioned hereof. So underline it in your books that you are having and learn them as soon as possible. Under Article 132, Subclause 1, an appeal shall lie to Supreme Court from any judgment, decree or final order of a High Court, whether civil, criminal or other proceedings. If High Court certifies that under Article 134A, the case involves a substantial question of law as to the interpretation of this constitution. See, as I have told you, I think I have told you in the previous videos that we have done, if there is a substantial question of law that a particular, see, when you read those RCs, reading comprehensions, when you have to read one line and then you interpret that what the author is trying to convey. So the constitution makers, they made that rule book and they have died. Now we cannot go up to them and ask that what is the meaning of this statement that you have written. So it is the duty of the judges now that how they will be interpreting a particular statement, a particular provision of Indian constitution, and how they apply it in practice. Like if there is a matter concerning a murder, then how you have to apply it, or there is a matter regarding equality of opportunity, of job opportunity to two parties, then how particular provision in the constitution, how that equality principle you will apply in the present situation, in the present case, that is interpreting it. Okay, that is known as interpretation of the constitution. So if in constitutional matters, see, appeal in constitutional matters can go to the Supreme Court by virtue of Article 132 subclause 1, and it may only go if the High Court is certifying that this particular case involves a substantial question of law and that can be dealt by the Supreme Court by analyzing and by properly interpreting the provisions in the Constitution. Then civil cases, Article 133. By virtue of Article 133, an appeal shall be made to the Supreme Court from any civil matter which lies or which has arisen by the judgment of High Court. Okay, so see, it can go up to the Supreme Court if it in two cases, in two situations, it can go up to the Supreme Court. First is that the case involves a substantial question of law which is of general importance. Again, how to decide how you have to interpret a particular article or a particular act or a particular book. Book means IPC, CRPC. There are various rule books that exist in India in today's period. So how you have to interpret it, that lies a substantial question of law, and one particular case can not only be beneficial to the two parties who are involved in that matter, but if it is of general importance, means that can also be relevant to the other people in the society. Okay, and if High Court is of the opinion that the said question needs to be decided by the Supreme Court, again the same thing, means we are not satisfied, we can go to the Supreme Court as an appeal, and if there is a substantial question of law involved in that particular case that can also be beneficial to the other people of the society, then High Court certifies that this matter should be dealt by the bench of Supreme Court. Then criminal cases, again Article 134 provides that an appeal shall lie to Supreme Court for any judgment in a criminal proceeding of a High Court. This can be made in two ways, without a certificate of High Court and with a certificate of High Court. Okay, an appeal lies without the certificate if High Court has on appeal reversed an order of acquittal of an accused person and sentenced him to death. Now please understand this. Civil and constitutional matters may be of relevance to the society as a whole, okay, but if there is a crime committed, then बाकी लोगों का इसमें कुछ फ़ायदा नहीं होगा, ठीक है, एज सच कुछ फ़ायदा नहीं होगा, जस्ट दैट विक्टिम विल गेट सम कॉम्पनसेशन और इट विल गेट सम रिलीफ, बट there is no other benefit. The person who has committed the crime will get some punishment as prescribed in the rule book, as given in IPC, Indian Penal Code. Other than that, there will not be any substantial question of law that would be of general importance, right? So in criminal cases, in two ways a particular matter can go from High Court to Supreme Court. If the High Court gives the certificate, as it was happening in these two cases, and also if the High Court is not providing the certificate, that this matter should be taken up by the Supreme Court, as it involves a general question of law which has to be discussed and decided by the Supreme Court judges. So in criminal cases, if there is an order that may or may not have been certified by the High Court, that yeah, I am certifying it, now you take this matter to the Supreme Court because it is of general importance. An appeal lies without the certificate. Without the certificate कब होगी? If the High Court has on appeal reversed an order of acquittal of an accused person and sentenced him to death. Means if there was an earlier decision of High Court that this is the accused person, and on the ground of benefit of doubt or any other ground, lack of evidence or whatsoever, this person was set free for about 5 years or so. Okay, so there was a crime which was committed by this person A, but because of benefit of doubt or lack of evidence or something like that, this person was set free for about 5 years. Now the case was reopened. कुछ हुआ, केस दोबारा खुला और तब बात आई that this person is actually the culprit. This person has actually committed the crime. हमने जो पहले से छोड़ा था वो गलत छोड़ा था. So now I am reversing, I means the High Court. The High Court is reversing its order of acquittal. ठीक है, the High Court is reversing, अपने ऑर्डर को ही वो पलट रहा है. It is committing, इसने माना that उन्होंने गलत ऑर्डर दिया था पहले, इस बंदे को छोड़ दिया था खाली, लेकिन यही कल्प्रिट है, यही अक्यूज्ड है. So now I am reversing the order and उसको पनिशमेंट क्या दी? डेथ पनिशमेंट, कैपिटल पनिशमेंट जिसको बोलते हैं, sentenced him to death. Has withdrawn for trial before itself any case from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to death. Now you see, lastly, if the capital punishment is being awarded to the person, then without the certificate of High Court, the party to the suit can approach the Supreme Court for fresh proceedings to take place in the Supreme Court. Okay, so फर्स्ट थिंग इज़ आपने उसको छोड़ दिया, लेकिन बाद में आपने केस जब रीओपन हुआ तो आपने अपने ही ऑर्डर को रिवर्स किया और कहा कि नहीं, ये बंदा कल्प्रिट है और हम इसको लाइफ इम्प्रिजनमेंट दे रहे हैं. देन And the second case is withdrawn for trial before itself any case from any court subordinate to its authority. So what it is saying that उसने अपने सामने किसी भी कोई छोटा कोर्ट का केस था फ्रॉम एनी कोर्ट सबॉर्डिनेट टू इट्स अथॉरिटी, उससे वो केस लिया, ठीक है, हैज़ विड्रॉन फॉर ट्रायल बिफोर इट सेल्फ एनी केस, अपने किसी जैसे डिस्ट्रिक्ट लेवल कोर्ट का कोई मैटर उठाया और वहाँ पर अब अगर आप कोई डेथ पनिशमेंट या कोई बहुत ग्रीवियस बहुत ग्रेविटी वाला सीरियस मैटर है, क्रिमिनल मैटर है, तो डिस्ट्रिक्ट कोर्ट के वर्डिक्ट को इतना नहीं इम्पोर्टेंस दी जाती है ऐसे मैटर्स पे, और उनका वर्डिक्ट को रिव्यू किया जाता है बाय हाई कोर्ट. तो अगर हाई कोर्ट ऐसे मैटर्स को डिस्ट्रिक्ट कोर्ट से हटाकर अपने पास लाता है और अब वहाँ पर भी प्रोसीडिंग्स फ्रॉम द ज़ीरो लेवल स्टार्ट होंगी, नई प्रोसीडिंग्स हाई कोर्ट में स्टार्ट हुई और उन प्रोसीडिंग्स में उसने पाया दैट दिस पर्सन हैज़ टू बी गिवन लाइफ इम्प्रिजनमेंट और ही शुड बी हैंग्ड, ठीक है. सो फॉर दैट केस ऑल्सो अब कोई इतनी बड़ी पनिशमेंट देगा, कैपिटल पनिशमेंट, सेवियर पनिशमेंट, सेंटेंस्ड हिम टू डेथ. सो अब यहाँ पर आप सर्टिफिकेट का वेट नहीं करोगे, जब तक हाई कोर्ट सर्टिफिकेट बनाएगा पता चला आपकी फांसी की डेट आ गई. So for these grievous matters you can or the parties can directly approach to the Supreme Court without getting a certificate. Advisory jurisdiction means to advise, किसको advice देंगे? President को, ठीक है. Article 143 reads as if at any time appears to the president that, now see, president may or may not be an expert of legal field, and if he needs some advice from the legal point of view on a matter, then it can take advice from the Supreme Court of India, and Supreme Court can render its advice to president by Article 143. So please remember this thing, the articles which are given. A question of law or fact has arisen or is likely to arise. The question is of such a nature and public importance that it is expedient to obtain opinion of Supreme Court upon it. He may refer the question for advisory opinion of court, and court may after such hearing, as it thinks fit, report to the president its opinion thereon. Now since it's matter of an advice, an opinion of Supreme Court, so whatever it feels to be correct, whatever it feels that this advice should be given in this matter, इस तरीके से उनको हैंडल करना चाहिए या ये हम एडवाइस देंगे. तो whatever their point of view is, they make a report and submit it before the President of India. In Reeve Kerala Education Bill case, now this is a landmark judgment, that's why they have given it, so please remember this. Kerala Education Bill case, Supreme Court laid down the following principles. Supreme Court has under clause 1 a discretion in matter and in proper case and for good reason to refuse to express any opinion on the question submitted to it for a good reason. Remember this thing, this is some keywords, there are some keywords that you can pick anywhere. So under subclause 1, the Kerala Education Bill case, Supreme Court laid down that under subclause 1, Supreme Court has a discretion, means if it seems fit for them, तो कोई ऐसे crucial matter है जहाँ पर for a good reason, for a valid reason, they can refuse to express any piece of advice. Question president ने पूछा और उनको कोई ऐसा मैटर लग रहा है जहां हमें एडवाइस देना सही नहीं है प्रेसिडेंट को, तो वो मना भी कर सकते हैं. It is for president to decide what question should be referred to the court, and if he does not entertain any serious doubt on other provisions, it is not for any party to say that doubts arise also out of them. So you see, if the president feels like, then he may put a question before the court for an advice. If he doesn't, then he is not obliged to do that, okay. And if there are some serious doubt कि इस constitution provision का मतलब क्या है, तब आप question put कर सकते हो. लेकिन कोई और पार्टी फिर ये ना कहेगी कि उनके पास भी क्वेश्चंस हैं, ठीक है. द क्वेश्चंस अराइज ऑल्सो आउट ऑफ देम. So remember, this is only for the president that the Supreme Court has to render its advice, and even if it considers that for a particular case their advice or their opinion is not required, or it's not good for them to express their opinion, so they can for a valid reason refuse also. Advisory opinion of Supreme Court is not binding on courts because it is a law within meaning of Article 141. So remember this thing, it is just an advice. You may or may not work according to the advice which is given to you by the people, right? So any advice which the Supreme Court is giving by its advisory jurisdiction, it is not binding on the courts. वो binding नहीं होगी. If you wish, you can apply on it. If you don't, then leave it. Special Court Bill case, Supreme Court held that its advisory jurisdiction are binding on all courts in territory of India. It also held that Supreme Court is under duty under Article 143 to give its advisory opinion if question referred to it are not vague and of a political nature. So now you see how the Supreme Court is with time to time it is changing its verdict. So orders do get reversed. अपने ही कोर्ट के ऑर्डर, अब देखो 1958 में कोई अलग सेट ऑफ जजेस होंगे, 1979 में दूसरे जजेस होंगे, and each person has a different point of view with which it considers or with which he tackles the situations, right? So इतने टाइम पीरियड में लोग बदले, उनका माइंडसेट बदला, उनके ओपिनियंस बदले. तो जहाँ उसी सुप्रीम कोर्ट इंस्टीट्यूशन सेम है बट लोग बदल गए. सो उसी सुप्रीम कोर्ट ने 1958 में बोला कि अगर कुछ ऐसा मैटर है तो हम रिफ्यूज़ कर सकते हैं एक्सप्रेस एडवाइस देने से. Okay, so if now see, next Supreme Court is saying that it has to give the verdict on any, and next in the next case it is saying that advisory jurisdiction is binding on all courts, and if the advice is asked for, then it is obliged, it is under duty by Supreme Court to give the advice only if the question is not vague. It has to give advice on all matters except that the question is not vague or of political nature. Next video.